Then we open it up for questions of the department staff as well as IA regarding that investigation, any questions that we may have. And from there, we can move on to various proposals as well as if we believe that there's enough information, if we want to go into closed session to discuss any confidential materials that we had to review or videos, and eventually make our way down to, after these discussions, to making a motion on whether or not we agree with the findings of IA, if we want to reverse the findings of IA or modify the findings of IA. So that's kind of the steps that we would be going through in this process. Did I leave anything out?
I think that's accurate. The important parts to remember is that the first thing the board will be asked after getting whatever questions that it has answered is, does the board have enough information to proceed?
Yeah.
So in the event that the board does not have enough information to proceed based on the record or questions answered, the board can then request additional investigation. If the board does have enough information based off of the questions answered and the record, the board then can go into the process of essentially making a decision.
All right. With that, Mr. Davis, could you give us a summary of the appeal that we are hearing today?
I will. In the instant case, we have complaint number 22-036. We'll refer to the appellant as the appellant. The date of the incident was March 14th, 2022. It occurred in the area of Hollywood Street Southeast in the city of Grand Rapids, and it involved Officer Walderman. The nature of the appeal is as follows. The appellant claims that during the interaction with GRPD, the appellant was the victim of an unreasonable use of force when the appellant was put in a headlock and slammed into cement. The complaint was made on the 25th of March, which is 11 days after the incident. According to the CDR dated August 18th of 2022, Officer Walderman's body-worn camera was not activated, and Officer Spees, I hope I'm saying that correctly, body-worn camera does capture a part of the incident. The police were responding to a misuse of 911 call, and that call was made by the appellant. The police alleged that the appellant called 911 56 times, beginning at around 1:57 a.m. on that day, but there were previous days of calls as well. The officers arrived, and the appellant was in an enclosed porch and, according to the report, was visibly intoxicated. Officer Walderman indicates that since Mr. Nugget wouldn't come inside, no arrest was made. If you were to refer to page 5 in your packet, which is the first page of the CDR, you'll see additional information that indicates, although obstructed Officer Speed's body-worn camera shows the arrest of Nugent taking place, Officer Waterman can be seen bending over while standing on the right side of the appellant while they are both on a small porch. Both of Officer Waterman's arms are extended towards the ground while he is bent over, and he appears to be maintaining control of the appellant by holding onto his upper body. The appellant appears to fall from the threshold of the residence and land on his knees and butt, which are underneath him, and he is bent at the waist. No struggle appears to be taking place, along with no force on behalf of Officer Waterman. Speeds closes the distance and assists with getting appellant back to his feet. After the appellant is in custody, he is escorted to a cruiser. The appellant is extremely unsteady on his feet during the escort to the cruiser. The appellant is visibly intoxicated and makes no claim of force used against him or injury. And it further states in the next paragraph that no resistance is observed. The next paragraph that's relevant for the purposes of this summary can be found at the bottom of page 5, and that's from the police report of Officer Walderman, which indicates after multiple attempts at getting Michael to come inside failed, we drove our cruisers out of sight and walked back up to the house. I stood near his door, and within a short period of time, he opened the screen door and leaned his upper torso outside. I then grabbed his arms as soon as I did, so he fell to the ground. We stood him up and placed him in handcuffs, checked double locked. He was searched, nothing illegal, and was secured in Officer Speed's cruiser and was transported to the jail where he was lodged. Ultimately, Internal Affairs held that the allegation of unreasonable force against Officer Waterman is unfounded, which means that the complaint of acts did not occur. The violation of the VARD procedure for failure to activate body-worn camera was sustained, which means there was evidence. The evidence was sufficient to prove the allegation. The complaint that's before this board at this time is that regarding the unreasonable use of force claim. That concludes the summary.
Thank you, Mr. Davis. With that, I would like to open it up for any questions that board members may have. You can ask questions of the Internal Affairs representatives that are here, training staff that may be present, City Attorney's Office, as well as OPA. Oh. Yeah, that would be helpful. Well, I don't know. I'm sorry. What was that?
Procedurally, it's a question and answer. So the board should propose any questions that it has and receive answers regarding it.
Thank you, though.
Mr. Chair,
Yes.
I would like to request that IA provide a description of their process for our benefit.
Would that need to be a voice vote or no? Okay, then I agree. I agree.
Sorry, the process that I would take to investigate the complaint?
Whatever you've prepared for us today will work. Thank you.
Okay. For the process of this complaint involving Mr. Nugent, he called into the Internal Affairs Unit on May 25th of this year and left a voicemail. His call was returned that same day by Lieutenant Forner, who started the intake of the complaint process, took pertinent information for him, determined that it was a qualifying complaint, and began, completed that intake process. Before we had a chance to make a move on this complaint process, Mr. Nugent did call back on June 2nd of this year, requesting an update, at which point Mr. Nugent was informed that more time was needed to investigate this complaint. He didn't have any new information to add at that time. He was unable to provide any explanation as to his delay in contacting Internal Affairs. He didn't contact us until May 25th, when his arrest actually took place on March 14th of 2022. Lieutenant Forner then assigned the case to me for investigation. I first began by listening to both recordings from Lieutenant Forner that she made of her conversations with Mr. Nugent. Those conversations were recorded in their entirety and provided to me. From those complaints, I was able to determine that Mr. Nugent's allegations were that he was placed in a headlock and slammed to the ground, and that the handcuffs were applied too tight during his arrest while he was at his home on March 14th for misuse of 911. I then began reviewing the reports associated with this arrest. A review of the incident report prepared by Officer Wartleman showed that he was sent to Mr. Nugent's house along with Officer Spies and Officer Swantek. They were sent there for an ongoing misuse of 911. It was determined in this narrative that between 1:57 a.m. and 5:27 p.m. on March 14th, 2022, Mr. Nugent called 911 a total of 56 times. 4 of those calls came in after 3:58 p.m., which accounted for those 3 police officers being dispatched to Mr. Nugent's residence. Mr. Nugent, it was noted in Officer Bortleman's report, he had been warned to stop misusing 911 or it would result in his arrest. This was documented in Officer Bortleman's narrative and also in a separate police report, which was prepared by Officer Laura Saxton on March 11th of 2022. The report, I reviewed that report as well. That report is noteworthy for several factors. In Officer Saxton's report, she indicates that he was also warned about calling 911 on March 11th. He was intoxicated when he was placing those calls into 911. He refused to exit his house when police responded there as a result of those calls on March 11th. And he showed officers, while he was inside of his house speaking with them as they were outside, he showed them they had a minor abrasion on his knee. in the narrative that Officer Waterman prepared on March 14th, he indicated that at 4:44 p.m., Mr. Nugent called 911 and indicated to them that he drank a half gallon of whiskey. When officers in their first response to Mr. Nugent's house, when Officer Waterman responded, he notes in his report that Mr. Nugent refused to exit his residence, refused to say why he called 911, cursed at officers, then retreated further into his residence. Officer Waterman, Officer Spies, and Officer Swantek at this point decided to attempt a different way of potentially taking Mr. Nugent into custody, and they stepped away from his house and formulated a plan that they would park their cruisers down the street, return on foot, wait outside for Mr. Nugent to exit, and then place him under arrest at that point. They completed that process. They parked their cruisers outside the view of the home. Officer Waterman indicated in his narrative that while standing outside of the front door of Mr. Nugent's residence, out of sight, Mr. Nugent opened the door and leaned his torso outside. Officer Waterman reports grabbing his arm as he exited, and that Mr. Nugent immediately fell to the ground where he was placed under arrest. Following being placed into custody, the handcuffs were applied to Mr. Nugent. They were double locked and checked for spacing. I then took the information that I gained from the narratives prepared and compared it to available video footage that we had taken from officers' body-worn cameras. Based on the tactics that those officers used by parking their cruisers down the street and approaching on foot, there's no relevant in-car video associated for this event. We can only rely on the body-worn camera footage. Officer Waterman's body-worn camera was not activated during this arrest, which is a violation of our procedure at the police department, and that was addressed. We'll explain more on this later. Officer Swantek's video footage shows that he responded to the front of Mr. Nugent's residence from the rear during the arrest of Mr. Nugent. Officer Swantek's body-worn camera footage shows that Nugent is already standing by the time he walks around to the front of the residence. Nugent appears to be barefoot, dressed in a robe and underwear. This body-worn camera, though, footage is noteworthy because it does show Officer Waterman applying handcuffs to Mr. Nugent and subsequently checking each cuff for spacing and then double locking them. A review of Officer Speed's body-worn camera footage shows him walking towards Mr. Nugent's house during the arrest. The view provided by Officer Speed's body-worn camera is partially obstructed by tall shrubs, which are bare of leaves from the winter season. Although obstructed, Officer Speed's body-worn camera shows the arrest of Mr. Nugent taking place. Officer Waterman can be seen bending over while standing on the right side of Mr. Nugent while they are both on his small front porch. Both Officer Waterman's arms are extended towards the ground while he's bent over, and he appears to be maintaining control of Nugent by holding on to his upper body. Nugent appears to fall from the threshold of the residence and land on his knees and butt, which are underneath him, and he's bent at the waist. No struggle appears to be taking place, along with no force on behalf of Officer Waterman. Officer Spees continues to close this distance and approach the front porch and assist with getting Mr. Nugent back to his feet. After Mr. Nugent is in custody, he is escorted to the cruiser. Mr. Nugent is extremely unsteady on his feet during the escort to the cruiser, and he's visibly intoxicated. And during this interaction with the officers, he makes no claim of force or injury. The next step in my investigation, I attempted or considered seeking out medical records. Through the conversations with Mr. Nugent, I was able to ascertain that he did not seek immediate medical attention surrounding his arrest. He did have a routine doctor's appointment approximately a week later for several long-term health issues, but not specifically for anything related to his arrest. I didn't feel that would be pertinent in this investigation due to the time delay and the nature of that doctor's visit, so I didn't seek those records from him. So my conclusion with this is, or I guess how I came to it, is Mr. Nugent made a complaint with the Grand Rapids Police Department Internal Affairs Unit on May 25th, 2022, stemming from his arrest on March 14th, 2022. He indicated that he was placed in a headlock and slammed to the ground after he poked his head out of the front door of his residence. I conducted a review of available reports and video footage. Based on my investigation, I determined the allegations brought forth by Mr. Nugent against Officer Waterman were unfounded. As you guys are well aware, at the conclusion of an internal affairs investigation, we have 4 possible dispositions to choose from. They are sustained, which would show that the evidence is sufficient to prove the allegations; not sustained, which means that there's a lack of sufficient evidence; exonerated, that the actions did occur but they were justified and lawful; and unfounded, the complaint of acts just did not occur. I chose unfounded for this complaint in regards to Mr. Nugent's complaint because he made very specific allegations about being placed in a headlock and slammed to the ground. My review shows that these allegations did not happen. I believe that it's an extremely high level of intoxication spanning the course of several days on behalf of Mr. Nugent plays a significant role in his recollection of the arrest that took place. I did take what was observed in the camera and noted in reports to his level of intoxication into consideration when assessing his credibility with filing the complaint and providing his recollection of events as well. Additionally, through my review of the video footage that's available, I do find that it supports what was written in the incident reports and the information that I gained when conducting interviews with the officers involved with this arrest. Additionally, as a result of this investigation, though, I did determine that Officer Waterman failed to activate his body-worn camera, and therefore a violation of our video-audio recording device procedure is sustained. Through my investigation, from what I understand, Officer Waterman had his body-worn camera footage on when they approached the house initially to address this 911 situation. The officers, when they stepped away from the house to formulate a different plan, they deactivated their cameras, which is permitted by policy. And when they reapproached the house, Officer Waterman failed to reactivate his camera, which then in turn is the violation of policy, and that's what was sustained.
Mr. Chair, just one correction. When I gave my resuscitation, I think I said March 25th instead of May 25th. I read the wrong M on my paper, so I just wanted to clarify.
Thank you for that,
my
'cause
note.
that
yeah,
kinda stopped
70
me.
days,
Yeah.
May 25.
All right, thank you. Then we'll return to any questions from the board members for you, sir.
Sergeant, I have a question for you here.
Sure.
Your investigation into the use of force, was that limited to the alleged use of force by the complainant or the appellant, is the term we're using, as to a headlock and being thrown to the ground? Or did you consider other uses of force within your investigation?
Yes, I looked for his specific allegations as well, but as I'm examining this entire arrest process, I looked for any signs of force being used.
Okay, then let me follow up with that. The laying of hands on this individual when he exited the residence by Officer Wurtleman, does that constitute a use of force? And if not, why not?
It does not. We have to place our hands on people anytime that we arrest them. We start by grabbing their arms. We have a trained policy or procedure for placing people under arrest, but we have to touch people to arrest them. So a normal custodial arrest is not considered use of force.
Anyone else?
I'm not sure how to phrase this, so forgive me ahead of time. I think one of the challenges that I'm having in terms of interpreting how this is custodial arrest versus use of force is the tactic of standing next to a door and waiting for someone to lean out. There's no indication that the individual crossed the threshold of his door, grabbing an arm versus a headlock. What's the training and the strategies that are provided to the officer in this type of situation? You said laying a hand on his arm to take him outside of his door. That's procedural? Just help me understand how that works and how that mirrors what training has been provided. And
If this is a training question, I'd prefer to
Sure.
refer to Sergeant Butler.
Yep, I think it's putting the pieces together. Thank you.
Afternoon. So as far as putting hands on someone to make a custodial arrest, I will concur. You know, we escort people often if we're in a crowd, if we need to get them to our cruiser to do some sort of search, to place them in the handcuffs where it's safer to do so. That's not a use of force. We're just simply keeping control of the situation. If somebody, now my understanding is that he did break the threshold of the house, would be similar to that. You know, securing an arm, all right, you're coming with us, you're now under arrest. Get them off that small porch, get them to even ground where you might then apply those handcuffs or complete your arrest process.
So it would be considered crossing the threshold if you leaned out your door, and that would be opportunity for an officer to take your arm and bring you the rest of the way out?
They would have to break the threshold to exit the house on their own, correct?
So step out.
Correct.
Okay, thank you.
Can I ask a clarifying question about that? When you say step out, so if the individual opens the door and leans out of the door, meaning their feet are still on the inside of the door, for purposes of your training, is that breaking the threshold?
We would want the majority of their body outside of that exterior of the house.
Okay.
Now, if they're stepped up here and they got, their toes still in the house, I would say they have made the effort to exit that home. It would be reasonable at that point to make contact.
Okay.
Yeah, let me clarify on that. Then, are we talking in terms, I'm a little confused. Are we talking in terms of policy, or is this a legal standard that you're going off of?
Yes, we do not break the threshold to pull somebody out of their home on a misdemeanor arrest.
Okay.
Anything further?
I think there will, I would say stay up.
So I've heard two terms through this particular case, and that in the video there was reference to a summons, and then in the documentation that we received, there was reference to a warrant. So my question is somewhat twofold. What is the difference procedurally then when it comes to making that arrest for the misdemeanor? And then also, what kind of implications would that have on the decisions that get made in the moment for the tactics used?
You're talking about, I guess, three different things with that question. The one that matters for this arrest is whether or not these officers had probable cause to make this arrest, and that's what they were acting off of. We did not know it at the time, or those officers didn't know it at the time. There was a process of a summons being issued from his previous misuse of 911 3 days earlier, but that was not yet known by these officers, nor would they be there to take him in custody for a summons. When we prepare a police report, it gets cycled through the police department, a detective takes it over to the prosecutor, and it's up to them if they decide to issue a warrant or a summons, and they take a variety of considerations into account when they decide which to go with. But that is not a police choice to seek a summons or a warrant.
If I may, in the videos, the officers are actually discussing that they did know there was a summons.
Oh, did they? Okay.
Yes. They discussed that they did know that there was a summons and that they were frustrated that it wasn't a warrant.
Okay.
And
that's
this was
very
what
possible.
started their process of discussing how to get him out of the house.
Okay. Yeah, this arrest was based off probable cause and not that summons.
Can you describe the difference between the arrest procedures or the ability to make an arrest, or maybe this is a question for the city attorney's office, but either way, in a misdemeanor situation? So first of all, this is a misdemeanor offense, is that right?
Yep.
Okay. And that these particular, based on your investigation, did you determine that these officers saw that misdemeanor happen themselves?
Yes, this was a long-term a long-term crime that was occurring on this particular day that began at 1:57 a.m. and ended at 5:25 p.m. with 56 calls being placed into 911.
I understand that part of it. I'm wondering, I guess my question specifically is, did any of these officers involved observe that misdemeanor conduct?
That's why they were sent there, was because of this misdemeanor conduct.
I think that's not the question. The question is, did these officers observe the misdemeanor conduct, the calling of 911 for an improper purpose?
I don't know that they would have observed it. They responded to the calls because the calls came into our 911 center.
And didn't one of those calls that's cited in the report, though, more than one, I believe, well, Of those 56 that were cited, one was cited in the report that said that he did call because of an allegation of assault or abuse.
Yes.
Is that correct?
Yep.
So they weren't responding because of an allegation of assault or abuse?
No.
Why not? If he called because he was being assaulted or abused?
Which incident are we speaking of that they responded to?
He had called I don't know which, because it's one of the questions that I was going to ask you, is why there wasn't a record of the calls placed, because there were so many, to see, because there was only a few that were cited as far as what they were in the report by the officers. But if he called about being abused, and in the first video, that body-worn camera video from the 11th, on the responding officers there, he states in that video that he had been abused by his brother, and his sister is on the phone, and his sister is saying that she believes he should seek medical attention. And the officer notes the abrasion on his knee, small abrasion on his knee. Also, I believe in one of the videos, I'd have to look through my notes as far as to the time and which video it was. There's also reference to a former PPO against his brother, who is the person that he's complaining against in the home, correct? For assault against him, and what he used to have that PPO against him.
It's possible. I'm not aware of that.
Well, it's discussed by the officers in the video.
Okay.
And so all of those things, I'm confused as to why nobody did show up for a call of assault or abuse.
And which call, I guess, are you referring to? Because I
These
see
officers.
that we did respond numerous times.
Oh, okay.
And that Mr. Nugent wasn't cooperative, would not come outside to speak with us.
So, okay, I guess for clarity's sake, then, we're only in the report that we're given here, we are only seeing calls that were on the 11th, and then calls that were on the 14th.
Okay.
And responding officers on the 11th, and then responding officers on the 14th. Are you saying that there were other incidents where officers did respond in relation to his complaints of assault?
Yes. I don't have those here, and I didn't plan on talking about those because I knew that you guys didn't have those, and I didn't use those to make.
You didn't use those in your,
process.
so you didn't investigate any of the other complaints that this person had put where they were coming in, where he was calling on complaints of assault or abuse?
Those complaints would be handled on the street by the patrol officers that responded there.
But you didn't use those as any sort of reflection on why he may have been calling again?
No, my investigation had to do with them arresting him for misuse of 911 after his calls became excessive.
But wasn't one of the portions of his complaint the fact that he was arrested for calling 911 because he was being abused?
Yes, but he was also warned to stop calling 911.
If a person believes that they are being abused or assaulted, who are they supposed to call if not 911?
If he calls us, we need to have him cooperate with us and come out and speak with us, and that's what we weren't getting from him when he was calling. So these calls that he was placing into the police department, we weren't able, if there was an actual allegation of abuse, assault, violation of a PPO, we couldn't properly investigate it because he would place these calls and not cooperate. So these calls in turn turned into a huge drain on police resources because then they became repetitive over and over. 56 times in a short period is excessive, especially when we're responding there. He's not coming out of the house. That's tying up our 911 operators. That's tying up police officers from responding to other emergencies in the city. There's 911 calls that can't be taken in as these 56 continue to come in.
So I just want to follow up. I apologize for monopolizing this. I will open this back up. My apologies. GRPD has CIT officers, is that correct? Mm-hmm. So a crisis intervention training officers?
Yes.
At any point during those 56 calls, was a CIT officer called to let them know that there might be a person in a point of crisis, even after a person called and said that they had drank a half gallon of whiskey?
Well, once again, even if we dispatched CIT officers, we would still need Mr. Nugent to come outside and cooperate with these calls that he's placing. They're just as limited as a regular patrol officer responding to this call.
But they come in, they do come with a social worker with them, correct?
But they still have no power to enter his home and
True.
enforce laws any differently.
True, but isn't it in the first video on March 11th, the first video that we saw, that I looked at, sorry, it shows him saying, "I want a social worker," because the cops weren't helping. And the officer's response in that moment is, "You don't call 911 for a social worker," right?
Could be.
Okay, that was the officer's response.
Okay.
And if you have CIT officers or teams, CIT teams that are in partnership with social workers to respond to these types of things, and you have a person who's called alleged assault, that was the first incident that that I saw in the investigation as far as an alleged assault. And being non-cooperative with the officer, clearly intoxicated by the reports and by his speech and actions in the video. Why wouldn't a crisis intervention officer be called? Why wouldn't a social worker be called in that situation?
Before I could even accurately answer your question and give it the answer that it deserves, I'd have to look back and see if we had CIT officers working that day and if that team was in existence. I do know that we deploy a team now on a regular basis, but I don't know if they were up and running way back on March 11th.
CIT, my understanding is CIT officers have been, training on the officers has been around for quite a few years.
Yeah, and that's what I'm saying. I don't know if one was working that day. The whole department is not CIT trained.
I understand that. I understand that.
Gotcha. I'm sorry. Our CIT officer program did not begin until July. Where the program where we pair a social worker with a police officer.
I know that is not the formal program that we have right now, which is the mobile crisis team, I believe. That started in July. Before that, there was CIT training of officers. I believe that started either under Chief Rahinsky as well as former Chief Payne. And in those trainings, they partnered with different social workers that would work all of Kent County.
It's hard to say. I don't know if a CIT officer was on the street on these particular
Understood.
days.
If I may jump in and just reframe a little bit, because I do like to give the board a lot of leverage or a lot of leeway to ask as many questions as possible, and I don't want to stifle the questioning by any means. I think that this dialogue is good. It helps us all gain a better understanding of some of the processes for the department, and I'm not at all going to suggest that you end that questioning, but I think that what the board does need to decide today is whether or not the use of force that was used at the time of the arrest was reasonable under the circumstances. And so whether or not the CIT team was in existence or dispatched prior, I think it could be relevant. And so I welcome you to continue to explore that as much as you deem necessary. But the further that we get away from the use of force on the date in question and the general implementation of different programming, I think the harder it might be to get to the decision that's in front of the board today. But that said, please continue your questioning, and hopefully it will be helpful to making the decision whether or not the decision by IA related to the use of force at the time that it was applied was the right one.
Mm-hmm.
Thank you. I wonder if the board has full clarity regarding the law as it relates to misdemeanor arrest. And I'm wondering if the city attorney's office can give some additional insight as to when officers can make arrests in misdemeanor situations, especially in the absence of a warrant and things of that nature.
Yeah, well, probable cause is the basis. There are certain things like civil infractions where you are not necessarily arrestable offenses. But you don't necessarily have to, if there's probable cause based on a totality of the circumstances, to believe that the person that you're arresting committed the crime in question, and the crime is an arrestable misdemeanor or felony, you can take them into custody. I mean, an officer can use all of the evidence at their disposal, whether it's institutional knowledge from shift changes to, and it doesn't have to be necessarily legally admissible evidence on the arrest side. When you get to court and have to prove someone guilty beyond a reasonable doubt, that has to be based on admissible evidence. But in order to arrest someone, the officers has to have probable cause, which is a lesser standard than beyond a reasonable doubt, in order to take that individual into custody. And so that is important, but I don't think the way that this complaint came in and the conversations with the complainant got to understanding his real complaint. It's my understanding that the Internal Affairs Agency kind of probed his initial complaint a little bit to see, is he complaining that this is an unlawful arrest, or is he complaining that we used too much force during the arrest? And it was their determination that the complaint was really about, did they use too much force when they took him into custody? And that's how they investigated it, and that's what the findings were. And so this board doesn't have the ability to reclassify it as an unlawful arrest case or investigation, but that might be something that you're considering when determining the taking of the individual into custody and the physical elements that were involved.
And that's why I raised it for board inquiry, because the question as to whether or not it's a lawful arrest would speak to whether or not force could be used or hands on and all those things could go on at all. So although it's not a individual allegations, and I agree that the board doesn't get to make a determination based on that for purpose of appeal, the board has to consider the totality of the circumstances to determine whether or not it was a reasonable use of force. So why the officers were using force, or as was classified, going hands-on, matters as well.
I just want to, I understand that, and I appreciate the clarification on both of those things. I just want to clarify the reasonings into why I was asking those things around CIT officers. And it's because the complainant in the transcripts that we have from the complainant telling when the voicemail was returned that you referred to, and the complainant is discussing what they wanted to have as a complaint. It is asked what on page 13 at the end, what would you like to see happen? I really don't know. I felt it was unnecessary that you know what happened, the way that the force was unnecessary. This is a question in response from the officer, that the force was unnecessary, or the fact that you went to jail. Both, yeah. So he clearly states that he was having an issue with both of those things, both going to jail, being arrested, as well as the use of force. And then again, in the follow-up interview on page 25, line 60, it says, "Okay, now are you wanting to make a complaint then about the arrest? Are you still wanting to do that or not? Yeah, I mean." So again, he clarifies, yes, I want to make a complaint about the arrest. So that is why I was asking those questions, because I am curious as to why it was clearly stated by the complainant in these transcripts as to why that wasn't included into the actual investigation of the complaint.
That's because I interpreted this as he was upset that he was arrested and lodged at the jail, and he was not complaining about charges against him, but he was upset and complaining about the actual physical arrest that he was a part of.
Okay, thank you. Did you ever call and speak to him about his complaint to clarify that in any way?
I did not.
All right, thank you. And sorry for monopolizing the time. Any other questions?
keep seeing other people moving to ask questions, but I don't want to interrupt here. I want to get back to this, whether or not force was used. I understand you said it's not, and I want to clarify. You know, I understand that not every laying out of hands constitutes a use of force, but when you go to take someone into custody, what action is required on the subject's part to convert this from, say, for lack of a better term, a consensual encounter to a resistance and use of force incident?
Can I refer to you?
Sure. It can be anything from passive aggressive, passive resistance, becoming dead weight, pulling, or more defensive where they're pulling away to cease you completing your process. Sometimes, they just lock arms in front of them. It's my understanding that he fell to the porch, like a loss of balance due to intoxication. I wasn't part of this investigation. I wasn't present. But so if an officer went to escort somebody and they simply fall from your grasp and you secure them there and then put them in handcuffs and they're already on the ground, they've already fallen, then that officer's actions didn't cause him to fall. There would be no use of force required. So it could be anything from tensing of muscles, pulling away, becoming dead weight, active aggression, swinging, turning away from you and, spinning away from you. If you tell them to face away from you and they turn and face you, that can be considered resistance as well.
Okay. So then, as to the investigation, then I'm not trying to. I speak very bluntly, and so I apologize. I don't mean any offense by this, but is it the understanding of the investigation then that his falling down was merely coincidental, having happened immediately after the officer laid hands on it? It had nothing to do with the two had nothing to do with each other.
Yes.
Any other questions?
In watching the camera footage from the one officer's body cam as he was approaching the door, and it's noted in the reports as well that it's very difficult to see beyond the shrubbery. I watched it multiple times and had difficulty seeing what was in the report. And I wondered if it was possible for IA to walk us through what they see, since you have far more experience watching these videos than I do. I think that would be very helpful.
If that's the will of the board, I would recommend, I've provided a legal opinion on this. I think that we should do that in closed session. The video contains some confidential information. It's only been minimally redacted, so we could get it to the to the CAB board as quickly as possible. So it is redacted for the CJIS information, and it would be appropriate to discuss the legal opinion and maybe have that process take place in the closed session due to the confidential nature of the information on the video.
Therefore, I'd like to move to enter a closed session pursuant Section 8H of the Open Meetings Act to consider the written legal opinion and the additional questions posed from the legal opinion provided by legal counsel that is subject to attorney-client privilege concerning the legal standards and procedures for an appeal under Section 10 of the FOIA.
We have a motion. Do we have a second? All right. Those in favor say aye. Aye.
Aye.
Those opposed? It carries. We will move into closed session. Do we need to set a period of time for this?
No, but I think that the clip of the video in question is not a very lengthy clip. So the approach to the home and the taking of the individual into custody shouldn't take very long, but it may take a couple of plays. So it may be the board's intent to take 15 minutes with closed session, but I think we would reconvene at a time to be determined.
Can I also ask to relook at Officer, is it Swannick's video as he is coming up as well? Because, yeah, I would like to look at that video again.
I think that's the same video.
It's the same. Yeah.
Okay.
Yep.
We'll reconvene as soon as we're done with our closed session on reviewing this footage. All right, it's 5:36. We're going to come back into open session. I appreciate everybody's time. I appreciate you going through the video with us and explaining that. Very much appreciated, and appreciate your patience in allowing us to do so. So thank you. So with that, I'd like to open it back up for any other questions that the board members may have for internal affairs for the city staff.
I don't have any additional questions, but I would just like to thank Sergeant Daly for walking us through. The videos are very difficult, and getting the play-by-play of your version was very helpful to identify pieces and components within the video that were otherwise difficult to see. With that, are we at discussion point, or are we still at question time, or?
I guess that's open still, just to see if there's any other questions for anybody. But are there any other questions? I have one more then, and it does have to do with one of the videos. It was that the video of, multiple different angles of the video and how the officer was, how the complainant was placed in the back seat of the vehicle. In the multiple different videos, the reason that I asked this is because in accordance with investigations, IA, when they see any sort of violation of policy or protocol or procedure, even if it wasn't a portion of the original complaint, you would investigate that, just as you did with the body-worn camera, correct? So my question along those lines is, because of the person being placed in the back seat of the vehicle, they were handcuffed, and they were not, I shouldn't say placed, because of the person getting into the back of the vehicle, and he was refusing to try to get up on the seat as the officers tried to place him in the video, place him in the seat. They shut the door and said, "All right, you'll ride like that then." And I understand that non-compliance, that is maybe an issue as to why the why the officers chose not to pursue getting him in the seat. But I'm wondering how that goes along with the policy for the prisoner processing and transporting that says that they shall be secured at a seat level unless it is unsafe or impractical to do so. He was already, the reason that I ask is because he was not resisting in any way. He was not showing any sort of aggression in any way in any of the videos. In fact, in the notations from everything, that he was not resisting, as notated in your investigation and report. So I guess I'm wondering why that wasn't flagged for kind of an investigation on it.
Because it was unsafe and impractical to expect those officers to force him into a seat based on his level of cooperation getting into the car.
Okay. And then even though he was highly intoxicated and not in full control of his body,
Yes.
it was unsafe for the officers to try to put him in the seat.
Yes.
Okay. All right. I understand the answer. I just have to, for point of clarity, like, I just wonder what would happen if there was an accident and he was in the back seat in that condition.
I don't think there's any reasonable way for me to answer that question.
All right. Thank you. That's the final question that I've got. Does anybody else have any other questions? All right. I guess that moves us. Thank you very much for your time and your answer. I really appreciate that. And that moves us into discussion.
So generally, for purposes of discussion, we raise the question so the board can talk about it. The first question before the board is there a motion to find that there is sufficient information for the board to make a determination regarding the internal affairs finding that the allegation of unreasonable force against Officer Michael Waterman is unfounded? And then discussion would begin on that topic.
Do we feel we have anybody have any feelings on that one way or another?
So moved.
So past the discussion phase.
So technically, there's normally a motion on the floor before discussion.
Oh, okay.
So,
My apologies.
So she made the motion, then if there is a second, then you would engage in
All right.
further discussion.
Second.
All right. It's open for discussion then. Correct? Just the motion on the floor, or do we need to pass?
You can have discussion. You open it for discussion pursuant to parliamentary procedure. If the board members don't have any further discussion, the chair would call it to a vote, which is not terribly uncommon either.
For discussion purposes, I'll simply say that I'm satisfied there's sufficient information to move forward.
I concur. The additional information provided by Sergeant Daly answered the questions that I had regarding the process piece, as well as what occurred and did not occur during that. I had, coming into today, after having reviewed the evidence myself, I found it difficult to understand why a decision of unfounded was chosen rather than not sustained.
Sustained, yeah.
But given the additional information we were provided and the ability to see how the training plays out in the particular situation within the video, my concerns have been answered.
Okay. Any other thoughts or discussion on it?
I think my thoughts are surrounding the fact that it was obvious someone calling 911 56 times or 59 times or however many times showed signs of distress, showed signs that something was wrong. And when we send police officers out to handle distress calls that need to be handled with by a social worker or by someone else, we get arrests. We get these. This is what happens, and so I am I shared the frustration of the officers as they were going through and watching through the videos and all of that. So I know how we got to this point, but I'm appreciative of the process of bringing on the CIT members and social workers to kind of go out and kind of help situations like this in the future so that we don't get to this point. I mean, and just the inhumanity that I saw with arresting someone in a robe, and I mean, just the embarrassment and the inhumanity of all of that bothers me. Even what you were talking about, Mr. Homestead, where he's sitting in the back in between, it just looks dehumanizing. And I want us to do better.
Mr. Chair, if I may, I appreciate the board's discussion regarding the topic in general. The question before the board at this moment is regarding whether or not there's sufficient evidence to move forward. It seems as if the board is ready to to vote on that topic. If the chair would allow the question to be called, then that would allow for additional discussion on that other question.
Yeah. Yes. So motion has been submitted. So do we need to do a roll call vote on this? So if you could call that out, please.
Russell Olmsted,
Yes.
Reginald Howard,
Yes.
Sophia Brewer,
Yes.
Jason Osborne,
Yes.
and Michelle Williams.
Yes.
So motion passes.
Thank you. The second question would be, is there a motion to affirm the internal affairs finding that the allegation of unreasonable force against Officer Michael Walterman is unfounded?
Well, if I may, before we discuss whether or not we want to affirm, reverse, or alter, or revise, is that the other official term? I can't remember. Modify, thank you. We need a point of I would like to open it up for discussion first before we decide that. Or is that not how it's done? Do we have to say yes or no on each individual one first?
So you don't have to say yes or no. There should be a motion on the floor. So this would be the question that someone can make a motion regarding, or whichever way they wanted it to go. They can make a motion regarding it. Then the board can engage in discussion regarding that motion. The discussion can be, yes, I think it should be this. No,
Okay.
I don't think it should be that.
Thank you. This can get confusing sometimes
No
for
problem.
us. So is there a motion then to affirm the findings in the IA investigation?
So moved.
Is there a second?
Second.
It's seconded, so I would like to open it up before we take a vote to a discussion around this. Does anybody have any discussion points around whether to affirm this?
Well, it seems like now is as good a time as any to go over some of my many notes over this. So I hope you'll bear with me. I talk for a living.
Bear with me, so sure.
So I'm going to try and put that to use here. I have a number of concerns about this case, which many have been expressed already. And a lot of this stuff is kind of those detail things that we've talked about beforehand, where, not everything is tied up in a neat bow. This isn't CSI where every plot line is resolved. There's an answer questions, as there always will be. But a couple things stand out, and I want to make note of them. The first concern I have is some questions about when the decision was made to effectuate this arrest. It's not clear to me that officers went to the location to arrest the appellant at the outset. It seems to me that was a decision that was made at the time. And one of the things that factors into that is that when we talk about this previous incident on March 11th, that the supplemental report indicating that charges were requested in response to that were not submitted until the 15th, which is after the second incident. It has a bad look. I'm also concerned about the fact that there were 15 hours of calls to 911 with no apparent responses. and it was only after a final call where the appellant said he wasn't going to call anymore that officers did respond, and the incident ensued. It's evident from the evidence that's been presented to this board that the appellant was well known to the officers even before these incidents took place. They were clearly dealing with him, as they indicated, frequently over the weekend, although we only have 2 reports from 2 different days. The frustration from the officers was apparent and understandable, both in their reports and in the video. I don't think there's anyone among us that can appreciate the frustration of being called to emergencies and then being turned away when police officers respond. The problem is that citizens are just that, they're citizens, and they take many forms, and they're in, they take many, they're in many different circumstances, right? And they don't have training. They don't always have, they're not always free of substance abuse issues or personal issues. And it's something that police are trained, we expect our police to respond to and handle professionally. I'll also note that, encountering people that are in various stages of crises, that are career criminals, that are drunks, mentally ill, each of these people can be victims of crime as well. In fact, as I understand it, the research shows they're more likely to be victims of crime. The appellant's reticence to speak to certain police officers in the course of his multiple complaints does not suggest to me that he did not legitimately believe that he needed police intervention or assistance. The evidence that I've been presented with shows that he articulated at several points that he believed he was a victim of domestic violence, and he told officers this. The officers made a judgment call and did not believe that those allegations were credible. And I guess that really kind of speaks to the crux of the issue that's before this board, right? These are all circumstances, the totality of the circumstances that go into the incident at issue, and that is the use of force. Now, having reviewed the video and the reports, I think the report is incorrect when it states that there was no use of force in this incident. I think laying hands on the appellant is a use of force, and I think it was done in response to resistance. Based on the Policies and Procedures Manual, it seems clear that the appellant was at least inactively resistant and passively resistant. And I think an argument can be made that he was using his Fourth Amendment protections in his home to avoid police officers gaining control, which would meet the definition of active resistance. In response, the officers made the decision, out of many decisions they could have made, one that comes to mind is they could have pursued a warrant and then presented the warrant to the appellant to engage his compliance and show that he had to comply. They chose not to, and that is certainly their prerogative. But the decision was made to, for lack of a better term, ambush the appellant outside his front door. When he came and poked his head out, hands were laid on his arm, grabbing him. I don't think there's any question that this was not an action that the appellant consented to. And I appreciate the response during questioning, but I do not believe, and it's certainly not reasonable to believe, that it was coincidental that the appellant fell down at the precise moment that hands were laid on. As it's been explained extensively to us, that the circumstances of this use of force do not mesh with understanding of training of how takedowns are made, how they're effectuated. But I don't think that that's what happened. I think what happened is that hands were laid on, and the individual was pulled out of his home, and he tripped and fell to the ground. While that's not within the training necessarily and what officers are used to do in use of force incidents, they are ultimately human beings that perform human being actions. And based on everything that I've seen, this seems to be not only the most logical set of circumstances, but it's the most evident of what actually took place. So the question then becomes, was this use of force objectively reasonable? And once again, we've discussed a lot of the factors that went into this, and I'm very torn on this ultimate answer, because while I think there were other options available to the police in the situation, I don't think that it was entirely unreasonable for them to conclude that the appellant did not have a legitimate criminal complaint when he called 911. I pause because that's a very close call for me. It was a very close call. Weighing against that are the fact that this was a situation where there was a non-imminent threat, where the appellant was contained within his household, where the police had ample opportunity to effectuate an arrest through other means than physical force. And so ultimately, I think that this, while I have very grave concerns about the behavior and the lack of patience with the police in the situation, I have a difficult time coming to the conclusion that this was, in fact, an unreasonable use of force.
Thank you. Anyone else?
As a point of clarity, just to understand the ultimate position that you were taking, were you saying that then you find, or your position would be that this was not sustained? If that were, and not sustained meaning a lack of sufficient evidence to prove the allegations, that, or were you saying something different? I just want to make sure we accurately understood your position.
Yeah, I think you need a clarification too, because exonerated has a very specific term for it as well.
And the board member doesn't have to commit to that. And right now, the motion on the table is to affirm the findings in the IA report. And so I believe that, the board member has the liberty to make the comments, and based on your comfort level, go as far as you feel comfortable going, but there is no obligation to state how you're going to vote before you actually vote. Your vote will speak for itself.
That's absolutely correct. I know that this board has discussed the fact that it has other obligations, so I wanted to make sure that if there was a lack of clarity was there, but you get to do it how you want to do it.
All right. I suppose to boil that lengthy diatribe down into a couple words, it's my belief that that I am struggling with the behavior of the officers in the situation. I'm not yet of the opinion that their behavior is objectively unreasonable, and I think there were significant deficiencies in the investigation into this incident as well.
Anyone else? Ms. Brewer, anything to add or say? For me, I agree a lot with you. With the sentiment of everything you bring up, there are a lot of things that I take issue with in the investigatory process. The fact that there are things that I do not understand why they were not investigated. I do not understand how This is the second time in the last couple of years that we have had a complainant make an actual complaint that simply was not investigated. And this being that the complainant made a complaint that they did not agree with being arrested for that violation. And that was not investigated. And this is, again, the second time in as many years that this board has had a case come before it where there was a complaint made by the complainant and no ruling was made or investigation made, in this case, towards that complaint. And I find that concerning. I understand that there's a certain amount of discretion, but if there is a lack of clarity on these things, then we need to have a process that is seeking to better understand and making sure that there is clarity there before it's proceeded. The process moves forward. There's also my concern on many of the actions of the officers involved in choosing to arrest, because I agree. From what I saw in the video, I do not see that they went there to arrest. They were responding to a phone call about another complaint of assault and asking, why am I here in the first one and then again, and even after being told that he was assaulted in both of them, or abused, I think was the term that the complainant used, that it wasn't pursued. And I understand that there may be, and probably is, more information that we aren't given here as the board as to why that is, but then that questions again why we weren't given that information so that we can have that come to that better determination. From my view in the video, it's extremely difficult to see from the angles on whether or not what the person crossed the threshold, left their own home, because of how far away the officer is in the responding body-worn camera video, even going through it as close to frame by frame as we were able to. And that's why, for my take, I can't vote to affirm it, because I don't agree that that it is simply unfounded. I agree that it is possibly, in my view, that it is not sustained because there isn't enough credible evidence to sustain the complaint. There's just simply not enough there to sustain evidence of excessive use of force. But I can't say that there is enough evidence to make sure to say that it's completely unfounded either. So, any other comments?
The only comment I have is, I'm new to this board, and this is the first appeal I've heard. And so your points of having seen a scenario with parallels before is well taken, but I think it seems to me that we should be looking at these cases individually. That the fact that there may have been circumstances in another case which are questionable, we're not here for that. We're here for a use of force incident and the investigation into that. And so I think we should focus on this case.
Thank you. Any other discussion? Then I'll call it to a vote. We have just so I get the wording correct. The motion before the board is a motion to affirm the internal affairs finding that the allegations of unreasonable force against Officer Michael Wortelman is unfounded. We need a voice vote on that. Wait, before we move forward, I'm sorry.
Yeah, before we do that, and again, I apologize, but I think it's a consequence of me being new, but I need a clarification on what the options were available to the investigation, and if you can reference, I have the materials here, I just need to reference.
Page 35.
Yep, page 35 of the last page of the packet. And that'll give you definitions on sustained, not sustained, exonerated, and unfounded. And just to be transparent to anybody who may be watching this at home. Sustained is evidence was sufficient to prove the allegations. Not sustained is lack of sufficient evidence to prove the allegations. Exonerated is the complained of act or acts occurred but were justified and lawful. And unfounded is the complained of act or acts did not occur.
Just to make sure I'm understanding correctly, the allegations is the use of force regarding the headlock and or is it use of force specifically? Because I think, I'd like a point of clarification on that.
So the finding is based on whether or not the force complained of was substantiated, and the officer, or sergeant, I should say, provided you the analysis that he used to come to his finding. And it's my recollection that his answers to the question was that he did consider the specific actions that were being complained of related to the headlock and to the takedown to the ground as to whether or not that use of force occurred. And so I think it's a big question, and you have to rely on both the investigation and the dispositional report that you have before you, and also the answers that were provided to you today.
I have to disagree at that point. I think when we spoke, when we asked the sergeant that was up here, I believe I asked him if he was looking into just the specific allegations that were made by the complainant, and his response was that he looked at those, but also the total circumstances and use of force outside of that.
I hope that's what I was trying to convey, that some of his findings related to those specific allegations led to his conclusions about the general complaint of the use of force. So I think we're saying the same thing a little bit different way.
You got all secretive. I just want to know.
Created some kind of internal row
Yes.
there, I think.
I guess for clarity around your question, though, I mean, we are voting to affirm. We are right now voting on whether or not to affirm internal affairs finding that it is unfounded, and that finding being specifically from page 6 on page 6 of the complaint disposition report, based on the investigation, the allegations of unreasonable force against Officer Michael Worlberg is unfounded. Okay. I think everybody's ready to vote. If we want to bring that to a roll call, please.
Russell Olmsted,
No.
Reginald Howard,
Unfounded.
So yes.
so is that a yes?
Yes. Yes.
Okay. Sophia Brewer,
Yes.
Jason Osborne,
No.
Michelle Williams,
Yes.
3 yes, 2 no's.
All right. So that means it is voted to affirm. I believe that closes this case then. I want to offer my thanks to Internal Affairs, the training staff, to everyone for being here this evening, answering the questions. I know this can be a time-consuming process, but it's an important one. So I really appreciate you all taking the time to be here and to continue to do the work. So thank you. and to city staff for bringing this report to us and in the condition that we were able to receive the documentations, because as I said earlier, it's amazing to have this packet in this way. So thank you. That brings us into the next item on the agenda, which is old business. Is there any old business to go over? I do not believe so. Opens up to open discussion. Any open discussions to be brought before the board?
Just given the fact that this appeal has concluded, we will call it now. There won't be a CAP meeting in January.
Okay. Do you need to?
I'd just extend my appreciation. I know the board took time leading up to this to come into our office and work around our open office hours to come in, sometimes multiple times, to make sure that you reviewed the information and took time out of your day besides the couple hours tonight. And we know that you're not paid to do this work. And I think that some of the feelings that you're expressing, it's okay to feel conflicted about this, and it is okay to apply your citizen lens. That's what you're being asked to do. But I do really, if you ever feel like you need some legal clarity around the precise role of this board, I'm happy to continue to have those conversations. And so the commentary, the observations, I think the feedback is good. It's okay to not have unanimous decisions in this space, as long as you're voting with your heart and you're voting with your mind. And so I just express my gratitude to you for the time you put in, and I know that you take this work very seriously.
Yep, I echo those sentiments. I also am extremely grateful that this board is so engaged. This board challenges the decisions of internal affairs. This challenges OPA, challenges the law department. And I think that's exactly what this board is supposed to do. And respectfully to past boards, it was not always the community's perception that was the function of the board. But I think that this board has shown its willingness to challenge it, but still to ultimately make the decision that it thinks is right, which I think is evident by affirming IA's decision. Even though, people call for other things sometimes. I respect that greatly and appreciate the fact that some of you remained on the board, Ms. Brewer, even though it's a little tight sometimes. So thank you all. And thank you to Internal Affairs. Thank you to all of the police department that's present today. I know that these processes aren't always fun, but I appreciate your professionalism as we walk through it.
I guess it doesn't need to be for discussion on this, but I want to make a point at our next meeting that we discuss. It changed on how we receive the videos and the content in how those videos were prepared to us in this one. And as I'm the board member who's been on here the longest, it's completely different than anything else that we've had before. And it makes it even more difficult as volunteers to get here to be able to review that and to be able to do it in a way that we can make sure to put enough time into truly understanding everything. I mean, we had, again, in point of context tonight, having to go just frame by frame in order to be able to see clarity on these things. It's really hard to dedicate that amount of time during when all of us have other careers and jobs that we have to do inside of this. So if we can dedicate some time to discussing why that is and figuring out if there's any way that we can if there's any sort of method that we can get to where we can get those videos included in these packets again, I'd appreciate it.
And if we can't, at least get a player that we can slow down and speed up so that we can look at things frame by frame.
Without the level of redaction that takes away the important parts.
Yes. Anything else? All right. And public comment would be next. Do you all want to say anything? No? With that, we're adjourned. Thank you very much. Have a Merry Christmas and Happy Solstice.